Hello, dear speakers. Hello, everyone who is listening to this. Welcome to Oxylabs legal webinar, uh, web scraping through a legal perspective. My name is Dennis. I'm a legal counsel at Oxylabs. And today I'll try to guide this discussion about web scraping from a legal perspective. And for this reason, we have invited 5 distinguished guests, professionals, and I think we can begin with their introductions. So, Alan, please.
Sure. Hi, everyone. Many thanks to Oxylabs for bringing us all together. My name is Alan O'Neill. I am primarily a big data engineer, and I've been working in web scraping for the last 15 plus years. In fact, I started before that. I scraped my first website back in about 1997. So that puts me back in the Stone Age, right? In addition to my engineering background, I also have a background in IT law. So I am very well versed with the legals ins and outs of the aspects of copyright and of access to data and different problems that companies and individuals can get themselves into by virtue of the fact of scraping a website and potentially breaching some computer access misuse laws, et cetera, et cetera. So it's a nice combination of skills to have, both the engineering and the legal side. So that's me.
Thank you. Brad?
I'm up. So good morning, good afternoon, I guess, depending on where you are right now. Here it's morning time. I'm Brad Gross. I am the founding partner of the law firm of Bradley Gross. We are a boutique law firm in Florida that specializes in technology law, intellectual property law with a concentration in technology law. So we have been representing OEMs, VARs, cloud providers, data aggregators, and so forth for well over a decade. I started out my career as a prosecutor, both in New York and then in Florida, where I founded the Internet and Computer Crime Division of the State Attorney's Office down here. And going back a little bit further than that, starting at the age of about 11, I was a hacker. I was a little mini hacker. I was hacking into government computers using my TRS-80 Model 1 Level 2, which is sitting about 10 feet to my left. Still works, by the way. Using a 300 baud modem and seeing what kind of information we could get off BBSs. But that led to a career in what I'm doing today. So thanks, Oxylabs, for having me, and look forward to the discussion.
Thank you. Mindaugas.
Hi, everybody. My name is Mindaugas. I'm a lawyer, attorney at law, partner in the law firm TGS Baltics, which is one of the biggest law firms in the Baltics. Myself, a couple of words about myself. I am in this field since 2000, basically, when I have started delivering lectures in Vilnius University Law School. So basically, since then, I am delivering lectures on data protection and data science, not only from the legal perspective, but also from technical and business perspective. My area is not only about data. My area is basically technology law. And it's already the 21st year I'm in this area, both on academic and practical sense of the word. Myself, well, I do not have a hackers basically experience. Maybe it's a pity and a shame to some extent, but what I was doing, I was coding my first web pages. I have coded maybe in 1998, 1999. And since then, I do know at least several things in coding, far more than just HTML. But well, I can write some code in Python and C++, which is, I would say, quite rudimentary, but still, I can grasp basically the meaning of the coders to some extent. In any case, I'm not a professional data. I mean, I do not have such a big and vast amount of knowledge in data scraping. I wouldn't say that I'm professional at all in this area, so I would be very happy to hear insights from the participants in the roundtable. Yeah.
Thank you. Sanaya, please.
Hi, everyone. I'm Sanaya Darawala, and I'm a lawyer as well, and I'm the general counsel for the web scraping company Zeit, which is formerly Scraping Hub. And my team basically does everything that runs the gambit in relation to legal and compliance as it relates to web scraping. So we primarily focus on EU and US laws, and we look at things like data protection under GDPR and CCPA, copyright laws, contract laws, the CFAA in the US, and things of that nature. So basically, everything web scraping, legal and compliance is what we live and breathe every day. So very happy to be here, and thanks for having me.
Thank you. Stephen, please.
Hi, everybody. It's Stephen Callahan here. I'm a partner in Dallas, Texas at the law firm of Sharon Callahan, Robson and Garza. We are a litigation boutique where we focus primarily on patent infringement. I've litigated patent infringement cases in the United States for over 15 years. Some of our clients include Ericsson, Samsung, Hulu, OpenTable, Cloudflare. So we do a pretty good bit of sort of high-tech work. And in the last, I would say, year and a half, 2 years, we have been litigating a patent infringement case involving web scraping. The plaintiff has a patent that they claim essentially covers a method of web scraping. So that's been quite interesting, and seeing how that patent may or may not fit within the US patent regime, including the Supreme Court's recent decision in Alice. So I'm very happy to be here. Thank you for having me. It's greatly appreciated.
Great, thank you all. So at Oxylabs, we really believe that this type of discussion is like really long overdue. And for this reason, for the, let's say, first episode of webinars like this, we decided that we should talk like on a high level and maybe a little bit broader basis about web scraping, and maybe in the future we'll deep dive into specific and separate topics. So for today's agenda, we'll begin by talking about web scraping, what it is. We'll later move on to talk about web scraping in a legal perspective, what legal questions should be raised when you're doing web scraping. If time allows us, we'll talk about web scrape, the differences and comparisons of web scraping in Europe and United States, if there are any differences. And the second part of the discussion, we'll try to deep dive a little bit more into what we have already mentioned, the CFA, GDPR, CCPA, and all of these fun legal things. And at the end, we'll probably talk about what's incoming in the legal industry, like what case law should we wait for, like what if there is any regulation incoming. So yeah, so that having said that, we can begin by talking about web scraping. I'm really amazed that all of you are like really deep into technical side and also have lots of experience in web scraping and in legal peculiarities of web scraping. But I guess, Alan, since you are the go-to guy when it's when you need to scrape something, and you have probably the most hands-on experience on scraping, could you, like in simple terms, explain to us what is web scraping, just so we speakers and participants and listeners know that we're on the same page, that we're talking about the same thing.
Sure, it's the same web page that we're going to scrape, right?
Yeah.
So I had a really cool conversation the other day, actually, with a corporate, a bunch of lawyers and accountants, and they said, what is web scraping? We don't know. Why would somebody do this? So this is a great segue into this. Web scraping consists of taking data that's on a website and doing something with it. Why? Well, we take this thing called web data. What is web data? Web data is interesting information that sits on a website. And pretty much every service that you use on the internet does some kind of scraping behind the scenes. So for example, if you're going to, and hopefully at some stage soon, we'll be able to go and fly away to our holidays again and stuff, right? And you want to go and find a nice priced hotel, you want to find a good connection on a flight. So what do? Do you go off and say, ooh, I'm going to go to Aer Lingus and Iberia and British Airways and Swiss Airways and Turkish Airways, and I'm going to just check all of those different itineraries and find the best route and the best flight for me? No, you don't. You go to Skyscanner or to Google Flight or one of these guys, an aggregator, and you say, I want to go from Dublin to Chennai. I want to go from then Chennai to Mumbai, and then Mumbai over to someplace in Indonesia, Jakarta, whatever, and do a world tour. To be an awesome thing. I'm looking forward to this after lockdown, right? But where do they get this data? Where do they get this information? Well, they send out what are called robots or spiders to these other websites on your behalf, and they put the same query. So they like make multiple versions of you, multiple human personas, and they go off and they take this information and bring it back to you, and they give you the best information that they can. So what web scraping does is it takes data from websites, turns that data into information, and then adds value by presenting it back to you in a particular way. So that's what web scraping is, and that's what it does. And every single time you go to look for cheap car insurance, a web scraper is used in the background to get that data. Every single time you go to look for a good deal on a holiday, that's where it comes from. And other people use web scraping for other things, like, for example, arbitrators. Or arbitrage. So I could say, well, I could set up a website to say, find me the best price for a ticket to go to a concert, right? And what it'll do is it'll maybe go and scrape 10 websites on this side, 10 websites on that side. Maybe, as you were saying there about different countries, Europe and America, maybe it goes in via a computer, let's call it, or an IP address in America, and then via a computer or an IP address in maybe China. And maybe because of those different markets, they're being offered two different prices. So it goes and finds where's the cheapest one, and then it sells it to you maybe with a 10% markup. And it's doing this arbitrage in between the two. So there's so many different ways that we can use the data that we get to convert it to information and to add value and then to make money on it. And that's what we do in web scraping. So I hope that helps to set the scene for what we actually do. We take this data. And of course, the legal question then, and the reason that we're all sitting here today that surrounds this is this legal? Is it legal for us as scrapers, engineers, developers, business analysts, whatever name we are in the industry, is it legal for us to go to somebody else's website and to take that data from it? And under what circumstances is it legal? Under what circumstances is it not legal? When we go and we send an automated script into that, is the very act of automation itself breaching some kind of computer hacking law or misuse law? So these are the kind of questions I believe that surround the web scraping industry. So does that set the scene, Dennis?
Definitely. Thank you for this, Alan. And really, you give us a wide explanation of what is web scraping and how it can be used. And like the act of web scraping, I guess, involves like different steps, like from sourcing the resources, the proxies of how you will be able to scrape to the actual data aggregation and later the data provision. So, and there are many different use cases as you mentioned. So I guess we can jump in here to the legal part. Like, do these different steps, different use cases, should they raise like different questions, and what kind of legal question should they raise? Like, let's say I'm a telephone book company. I scrape a website called abcd.com. I hope there's no such website, but please do not scrape abcd.com. But let's say I'm that company, and what should I think about, like, when I begin scraping? Sanea, maybe you could.
Sure. Yeah, kind of, the one thing I always say to people is there's no law out there that says web scraping is illegal or that like directly speak to it. It's all these little other laws that relate to web scraping, and that's where you have to be conscious. So it's not so much the web scraping itself, but it's how you scrape, what you do with the data after you scrape. Those are kind of the big considerations that we think about. And I'd say maybe the top 3 things that we look at are copyright issues. You want to make sure that you're not running afoul of copyright law with your scraping and with your use of the data that you scrape. We also look at contract laws as they relate to terms and conditions on a website. There's the concepts of browse wrap and click wrap terms and conditions, and how the law looks at those 2 differently, and public data versus non-public data. And so you want to take those into account. And then we also look at personal data. So you want to make sure that if you are going to be scraping personal data, well, first make sure you know what personal data is. So a lot of people get confused as to what personal data actually is. So know if you're scraping personal data, and if you are, know what laws you might run into, like the GDPR in the EU, like CCPA in the US. There's various laws in other countries. Australia has its own laws, Canada, et cetera, et cetera. And then also the big fun one in the US is the Computer Fraud and Abuse Act, which is, supposed to be an anti-hacking law, and there is lots of litigation around it, and lots of cases we're watching to see maybe if we'll get some guidance there. But that's another big one that you want to take into consideration as well. So those are the main things that we focus on. Is your project going to run afoul of these various laws? There might be other ones in other different scenarios, but those are the main ones we would focus on.
Thank you, Sonia. That also really sets the scene for us for our further discussion. But before that, I agree that I obviously agree that there's no specific law or regulation that regulates scraping. But do you guys think that there should be one? And is it possible to regulate like a process, an action? And have you heard of either in Europe or in the United States that some kind of regulation that could heavily impact scraping could come into force?
Well, I'll tell you from my perspective about whether there should be a law related to it. I think that type of law, if you really tried to address it, would be so ambiguous, or would have to have so many different loopholes that you could drive a large truck through it. So at some point, all of the exceptions would swallow the rule. And I think that that's probably why no such rule has ever been implemented or even tried to be implemented, at least in the United States. I think that's especially in instances in which a website is on public view, public display, not credentialized, right? Meaning there's no gateway that you have to get through to provide, to be able to have access. Essentially what you would be saying is, we're going to establish a rule that says, don't look at me, don't look over here. It's not so much don't enter, it's more of a don't look. And I know that there have been analogies to physical locations, right? Where we have laws that say you can stop someone from entering your store, your place of business, your home. And that's true, but that usually requires an affirmative act, opening a door, stepping through a gateway, doing something to put yourself physically in a location where you're not supposed to be. A screen scraping statute would be akin to saying, don't look at my house. You could look at every other house on the block, and I know my house is available for everyone to look at. I mean, it's right there, but you're not allowed to look at it. Not just enter it, you're not allowed to look at it, because that's essentially what screen scraping is about. You're looking at a screen that's not credentialized like everyone else can, and you're merely taking and then ultimately regurgitating somewhere else the stuff that you saw right in front of your face. So I'm not sure how you would ever pass a law to that extent. And I know, as Sanea, I hope I'm pronouncing that correctly, said earlier, we're really now trying to shoehorn existing laws to apply to that type of paradigm, especially with the Computer Fraud and Abuse Act. And that's really what it is. We're shoehorning things or trying to use laws and statutes that were never intended to apply in that arena. I don't think they should be applied in that arena, and I don't see how a law could properly be implemented to prevent screen scraping. That's my opinion.
I mean, I agree 100%, Brad. Yeah, I think if you, exactly what you said, if you tried to create a law like that, there would have to be so many exceptions and so many, ins and outs of it. It would be impossible for it to be a well-crafted law that would be enforceable in a meaningful way.
If we look also at both what Brad said and what Sonia said, which I think is going to fit into Stephen's area of expertise. So you both talked to the issue of access, and Brad was talking about, you may it's like the soliloquy from one of those famous movies, you can look but don't touch but don't taste but don't enjoy, right? And the thing is that what Sonia was saying was that we have to look at when we go to a site, we need to examine first of all what we're trying to do here and what is the data that's on that site and what are we trying to get. There's a very fine line between what is data that is public and open and what is data that's proprietary. And there are existing laws that fit into this thing. So we have the database copyright law, and database copyright says that if we have a database, well, then we have a copyright on that. Okay, but does that mean that if I take a listing of flights from Heathrow to Vilnius, that I can put a copyright protection on this? Well, yes and no, because if it's just a listing of something that happens, well, then you can't copyright it. On the other hand, if I add some kind of significant value to that, right, well, then I can claim copyright protection on it. So there's a very fine line between what is public and what is public but is also copyrightable. And this is where the very careful consideration of our legal brethren is what helps keep us away from the man with the curly wig, right? Then the other aspect, which I think is quite interesting, and I think Stephen could talk to it, is what you just said there, Dennis, about things like patent and things like copyrighted processes and patented processes. And I know that, for example, there's quite a difference in opinion between the European view of a patent and certainly software patents and the American view of software and software patents, where a lot of times when we look as a practitioner, and I'm putting on both my engineering and my legal hat now, right? So when I look at this as an engineering legal practitioner at a US patent, a lot of times I just see a business method. That's what I see as the business method, and I don't see that innovative, unique step, et cetera, and a lot of times what seems to be locked down in a US patent wouldn't get past the first hurdle in an EU court. So I'd love to hear your perspective on what that relationship between somebody going out to either patent a method of displaying this information that allows them to claim that maybe it's a database and proprietary versus the methods, for example, like the one you're talking about there, where someone claims to have a monopoly, which is what a patent is, on a particular method of scraping.
Mm-hmm. So yeah, so I can try to address some of that, I guess. That to begin with, I would say that the patents that are issued in the United States are probably more generous in terms of the patents that are issued in the EU and other countries. We issue a lot of patents here. And over the last 15, 20 years, there have been a significant amount of reform in the patent infringement litigation space, both judicial reform from our United States Supreme Court and our Court of Appeals for the Federal Circuit, which is the intermediate appellate court that handles all patent cases in the United States. and Congress has passed significant reforms, in particular the American Invents Act of 2012, to attempt to combat a couple of things. Number one, the patent troll that I'm sure a lot of folks here have heard about. Certainly, if you practice in the United States, this is an entity who acquires a patent of dubious quality from somebody else. This is a shell company, typically, doesn't make its own products, and then takes its overly broad and likely invalid patent and turns around and sues dozens or hundreds of other entities. So that has been an issue. We still see some of that going on, not as much as before, because there are now a number of tools for defendants in the space, including venue restrictions, the ability to challenge the patent at the patent office in an inter partes review or post-grant review. Some early ways to challenge the patent on a motion to dismiss, to challenge the patent as claiming unpatentable subject matter, et cetera. But in terms of web scraping, and if you think about, I guess, fundamentally what is going on, it's from the technical perspective, and I'm not a technical guy, but I at a high level, I understand what's going on. Is you're essentially using computer devices to send and receive information, data. And over the last 5 years, there have been a number of cases coming out of our courts, including the Federal Circuit Court of Appeals, which for most purposes is the end all be all, unless you can get up to the US Supreme Court, which is very rare. They've sort of come out and said, sending and receiving of information using general purpose computers is not a patentable invention. That is an abstract idea. It does not pass 35 USC 101 of our Patent Act. And the related Supreme Court Alice case in the Alice versus CLS Bank case. And it's abstract, and you can't get a patent on that. And so we see a number of these types of sort of general purpose general purpose computer sending and receiving of information. Patents fail. They regularly fail. And unfortunately, there's no hard and fast rules. And when you're looking at Alice and its progeny, in federal circuit, judges will say the same thing. They'll say it's nearly impossible to reconcile one decision with another decision. And you try to put your facts into one bucket of patentable, and the other side, depending on what side you're on, tries to put it in the unpatentable bucket. And some calls are easier than others. Some, you can't really reconcile them. Moral of the story, though, I think that if you're in the web scraping business, the developments that we've seen in the United States over the last 6-7 years will be favorable for you, because the type of patent that could plausibly claim web scraping, in my opinion at least, would have a very difficult time surpassing the abstract idea test that was announced by the US Supreme Court in Alice. You've got to really put something more in, and if it's just the sending and receiving of information using general purpose computers, that's not likely to pass muster. Now that's separate and apart. If you get the patent of how much trouble you can wreak on a defendant in the U.S. litigation process generally, and how expensive it is, et cetera, because you have to engage in the process, which is long and drawn out and not terribly fun. But I would say that the patent reform, in my opinion, for web scrapers, has been a positive thing, because it's given you a lot of quivers in your arrow if you're faced with somebody who claims they have a patent on a method or a system for scraping.
The other interesting thing, I know Sania might be able to talk to this, because I know that the company formerly known as Scraping Hub has a recent patent in the area. One of the interesting things in the area is, no matter whether the patent is done in Timbuktu or in Chennai or in Delhi or in Dublin or in Florida, there's still basic bars that it has to go past, and there's still various levels of acceptance of what constitutes a patent. And one of the more basic ones is that it is novel, right? And that it is something that somebody who is well versed in the state of the art would not reasonably be expected to come up with. Okay, that's like the basic bar. But the interesting thing that I find at the moment in relation to patenting all sorts of technology, not just this here, and I'm sure it's a conversation for another day, just to drop this little one in, is that as we start to use machine learning, AI, neural networks, et cetera, and as that knowledge becomes more ubiquitous, and as people become more and more aware of it, what previously was esoteric is now common knowledge, right? So what one person thinks is unique, in actual fact is no longer this, it's beyond the state of the art. It's just easy to do. So I'm sure that will raise issues as well in the patent courts in future years as to what one person or organization thinks actually meets that bar, when you actually put it to the acid test of, well, could a reasonably knowledgeable person in the sphere come up with this? You know, I think a lot of things are going to fail in the future because of this greater knowledge that we have. And that's that side there. The other interesting thing to come back to it and to keep coming back to it, I think, which is the more important part, not to do with patents, are the daily challenges that we face when we're scraping. And again, going back to what Sania had said, I think there's probably, and I think between the expertise we have here, there's probably a checklist that you could come up with and say, well, here are the things that you need to consider when you were thinking of going to a particular website. What's the data? Does it meet the test of being personal data under GDPR? Is it open? Is it behind a terms and conditions? And if so, have you read those and are you meant to agree to those? And we know from the case in relation to our friends Ryanair, does anybody, I'm sure everybody here knows about Ryanair. Who wants to talk to Ryanair? And because I don't want to dominate here, who wants to talk to Ryanair and how they fell on one horse but actually won on a different horse? Who would know about that?
Yeah, since Ryanair is definitely pretty known, especially in Europe, and they're known in the scraping world also because they're really active in defending themselves here. So maybe since about Europe, maybe Mindaugas, you could jump in here.
Yeah, sure. Basically, it's everybody. I concur with
Mindaugas, could you speak a little bit closer to the
I mean, the most provoking question you have raised in the beginning, and it's also quite provoking in terms of European regulation, is whether we need a separate law for data scraping, which of course I agree would be quite a nonsense. And it's impossible to have one. And it resembles me the earlier days in Europe when we had a discussion on the IT law back in 2000, in the year 2000, and then we ended up with law on e-commerce, which ended up in regulating some very, very, tiny fragments. In other words, at the end of the day, we found that there is not that much we actually can put in this law because there are so many different angles and aspects to the life that it basically makes no sense. From the European perspective, and Ryanair case, Ryanair cases which you have spelled out, actually, it's difficult to ignore the pattern. The pattern European courts are taking in respect to the web scraping, and it's really difficult to ignore the pattern which regulators are also keen or at least planning to take. And basically, I would say that there are at least three basic approaches which more or less are handled as a tools by European courts in dealing with the web scraping, including the Ryanair cases. The first one is the matrix approach, right, which Sanea exactly mentioned, which is that it's impossible to say blindly whether data scraping as such is legal or not legal, because I mean there are at least 5 moving parts, 5 moving elements, and depending on the composition of these 5 moving elements, the same action can be both legal or illegal. For example, we have a body of law in Europe. I think it's very similar to what you have in US, which more or less is applicable, right, in principle to web scraping. And the copyright is, I would say that we have intellectual property more than copyright, right? Because intellectual property law, it covers also database protection, trademark protection, look and feel of the website protection. So basically intellectual property law. Then of course, privacy law or data privacy, which is GDPR, and everybody more or less knows that this is some angle. Then we have like information security laws. Every state, I mean, every European country has information security laws, which are dormant, as Brad said, in most of the countries. And Lithuania, believe me or not, we have like several clauses in the criminal law which make it illegal to access the information system, either public or private, without authorization, which, if treated broadly, can be easily applied to web scraping. I mean, if you want to do that, I mean, we have this dormant clause which was never applied to my knowledge at all, even not talking about web scraping, but still we have information security law. We have, of course, terms and conditions or contractual laws, which is the weakest defense you can have as a, website or, information system or information resource owner. Then we have competition law, and competition law is exactly what discourages us from US, and I will say you just in a couple of minutes the view the European courts already have taken. And we have some other areas of law, but basically these are the most important. Then the application of these laws depends on the way the owner of the assets behaves itself or himself. It very much depends on how the owner itself, discloses, or what the message the owner of the asset says to the public. Whether it wants to reserve certain areas for himself, whether it wants some areas of the public domain to be kept, even if it's available for public, but to be kept from some activities or not. So basically, we talk about cease and desist letters, we talk about the terms and conditions and the banners and so on, but basically the robot.txt, the stuff like that. But still, it very much depends on how the owner of the asset treats this asset himself. Third, as Sanea said, it very much depends on how the web scraper behaves, right? And interestingly enough, we have some cases which suggest that there is a big difference whether the web scraper declares himself that these are the crawlers, right, and these are the robots, or whether it intends to disguise and basically to conceal that and to behave as if non-robots being robots. I mean, and this is also something which is deceptive action. And I mean, being a robot is not a problem as long as you declare that you are a robot, but concealing that you are a robot and concealing the IP addresses as if they are human being, generated, or human being assigned IP addresses might be a problem. So this is the aspect. Then it very much depends on the domain, exactly, whether it's private or public data. Yeah, it very much depends on whether the data is structured or non-structured, because structured data is one thing, non-structured data, publicly available data, interesting data is afforded a bit less of protection, and so on and so on. The second approach courts take is the shopping mall approach, and you always should take this approach in applying the plethora of these legal bodies in the courts and basically in the practice. And the shopping mall approach says that, look, what's legal offline should be legal online, right? Which means that just imagine the landlord, right, and the tenant, and what kind of, rules you would be surprised by entering the shopping mall. And again, is it legal, for example, to make photos in the individual shop in the shopping mall in US? I don't know what's the answer. I mean, even if when entering the shopping mall, normally you do not sign any rules, or you do not sign any terms of conditions, because there are, I mean, certain rules which you as a reasonable person anticipates, right, to apply, even if those are not municipal laws, even if those are pure internal rules of the shopping mall owner, rules for the visitors, but there are rules which, well, you normally expect, right, to apply. No pets, no photos. And no photos is exactly at the heart of the web scraping in terms of the offline world. And we had several cases where looking into the prices is not a problem. Writing the prices down is not a problem, but making a photo in the shop, making a photo of each price tag is a problem. And why is that? What public good or what private good is being defended by prohibiting making photos of the price tags in the individual shop at the public mall? So the shopping mall concept is very difficult to apply, because it has so many angles and so many aspects. And the third angle we should always keep in mind is the competition law. And competition law is extremely important in this case, because there is, there is the doctrine of essential facility, which is stranger thing in the US. And the essential facility doctrine has been applied already consistently by European courts, Microsoft case, MIS case, and it can be exactly designed to protect, the secondary markets, the downstream markets, from the dominant upstream markets. In other words, I mean, if the online platform is big enough, right, it cannot actually foreclose access to the public domain for smaller competitors who would, provide or who would create the products in the secondary market. And exactly, Skyscanner is exactly the example of the secondary market. And the Expedia is exactly the example of such a secondary market. And these defenses basically exactly lie at the heart of the Ryanair, or may lie at the heart of the Ryanair cases. I mean, which means that smaller online platforms can be afforded much bigger, protection for their know-how, for their business models, which basically are intellectual property rights, than the dominant online platform. So basically, Matrix, shopping mall, and competition law, these are the three tools we have in Europe.
Thank you, Mindaugas.
Yeah.
Thank you, Mindaugas, for this. As we have established, probably the common grounds here that there isn't going to be, neither in European Union, neither in United States, one miracle regulation that is going to explain how everything should be done. Since we have established that, and our listeners shouldn't wait for regulation or miracle, also case law, I feel that at some point there should be an agreed and common sense web scraping standards. And I think that we already know and feel what these standards would be and should be, and maybe already are, from the case law, both in European Union and in United States. So maybe Senea, could you try to elaborate on this topic? What should be considered as a good standard of web scraping?
Yeah, sure. So actually, to Alan's point earlier, you're talking about there should be some sort of checklist, right, that we can look at and say, because it's really hard as a web scraper who's not a lawyer to come in and understand copyright law or understand, the CFAA or competition laws or any of that. So having that checklist is really useful. And that is something we utilize internally at Zeit. We have a best practices guide. Everybody who comes into our company is trained on this guide. And what we tell them is, we don't expect you to learn the law. We expect you to understand that these are the triggers in a web scraping project that should bring you to the legal department, and we will then review the project. And I think that's like the best way to go about it. And then as far as standardizing those more across the board, like obviously this is internal thing, which we use, but we do share a version of it externally as well. But having those kinds of standards, there are things taking place around that. They wouldn't be regulations. They're not enforceable. They're just industry best practices standards. So in the US, there's SIA. It's a body that works with like financial institutions and things of that nature. And they have an alternative data council, which I'm a part of and which other lawyers are a part of. And they're putting together web scraping kind of regulations and guidelines. This relates very much to like alternative data and finance, which takes a very, very strict view of things. But they are putting together kind of those best practices. And so there'll be, you know, a one pager on copyright laws. There'll be a one pager on data protection and things of that nature, so that people can start to get an idea of what the industry as a whole thinks together. So I do think that's that will eventually be a really useful tool when it's a bit more complete. But to start, you know, having that best practices checklist is a really good place to start. If you're working with a web scraping company, you know, like yourself, Dennis, or like Zeit, that has internal legal teams, you'll probably get that handholding a bit if we're doing a project for you. But if you're doing it yourself, knowing when you should be consulting a lawyer, having that checklist is probably the best way to go to start.
I want to go back a little bit to that simple and small company that scrapes the non-existent webpage abcd.com, hopefully. And let's say I'm part of that company and I received a cease and desist letter. Obviously, I should hire a lawyer and consult with him before taking any actions. But for the sake of argument, what should that company do? And maybe Stephen and Brad, could you, from the US perspective, elaborate what should be done when one receives cease and desist letter?
Brad, do you want to go first?
Sure. From my perspective, in relating only to US law for just a moment, if a company that is scraping a screen or screen scraping receives a cease and desist letter, the company has a choice. The company's going to have a choice. And I think that anybody who says it's clearly one way or clearly the other is probably misguided. If you receive a cease and desist letter, you're going to have to make a decision as to whether your activities are, in light of the high Q case that we'll talk about, in the Van Buren case that's pending, and now, by the way, just about 2 weeks ago or so, another case was filed. Southwest Airlines was filed in the Northern District of Texas, I believe, right in Steve's stomping ground. They're going to have to make a choice as to whether they want to take a stand and take the position that HiQ took, which is essentially the CFAA is not intended to cover this type of thing. And just because you send a cease and desist letter doesn't mean that suddenly we are now expanding the parameters of the law. Or you take a position of let's wait and see. Let's wait and see what happens. Let's wait and see if HiQ is ultimately accepted by the Supreme Court. Let's see how the Supreme Court rules in the Van Buren, which I think is a little bit different than maybe a pure screen scraping case, but nonetheless tangentially might relate to things. Ultimately, there is a split in how these courts are looking at this. So, you know, in my view, I think that if you said, well, we want to proceed, we believe in the high Q logic, we think that that's the stronger argument, then you would go to what Sinead was saying earlier, which is create a sort of checklist, create a list of do's and don'ts, good and bad, and start erring on the side of good, right? Start erring on the side of only non-credentialed public-facing type of things. If there's a gateway, if there's a click-through, then we're going to avoid it, and so on. You know, really take the best approach that you can take, short of complying with whatever is being demanded in the cease and desist letter. But ultimately speaking, it's an open area right now, and we're going to have to look to the Supreme Court for guidance.
Yeah, I can just add a couple things maybe to that. often represent people who receive cease and desist letters. I've represented people who receive cease and desist letters in the scraping industry. And I agree with Brad completely that there's no one size fits all response. And so some of the options, the first thing I would say is, what is the site you're scraping? Who is issuing the cease and desist letter? And I'm going to address it from a litigation perspective mostly, and getting into court and kind of battling it out, and because that's what I do. And so the first thing I look at is who sent you the letter. What is the realistic likelihood that they are actually going to do anything? Because it's one thing to send a 3-page letter. You can whip that out overnight. Maybe you pulled a form down from online. It's another thing to actually bring a lawsuit against the scraper. And my guess is 9 times out of 10, if you ignore that cease and desist letter, nothing will ever come of it again. So you might want to ignore it. And I have clients who do ignore those. I have clients who ignore those types of letters in the patent space all the time. Literally get the letter, throw it in the trash because they know nothing will come of it. Perhaps not the best practice, but that's what some people do. You can also respond and explain why you disagree with the C&D person. And point out the cases that are favorable for you and take your stand. But the likelihood is you're probably not going to convince them to change their mind. And so you are putting up your position, because if things progress further down into litigation, you want to be able to say, look, I just didn't throw it in the trash. I didn't ignore them. I actually responded in good faith. I am a good faith player. And what you're looking for at the end of the day is to try to present yourself in a good light before either the court or the jury. And so that's another thing that you could do when you receive a cease and desist letter. You say, hey, I got your letter. Thank you for sending it to me. Lo and behold, check out, case X, Y, and Z. I feel like I'm on the side of angels here. So thank you. Then you can get even more aggressive. And I think they did this, although I can't remember in the HiQ case. You can actually sue them, right? So what we have in the US at least is the ability to file what's called a declaratory judgment lawsuit, where the accused wrongdoer actually strikes first and brings a lawsuit saying, essentially, no, I am not liable for whatever. You say I violated the CFAA, you say I violated some trespass to chattel, state statute, copyright law, trademark law, etc. I didn't do it. And that, depending on who sent you the letter, that may be a good strategy. So let me give you an example. If Google sends you the letter, that's probably not a good strategy, because Google has more money than God, and Google will be happy to litigate your lawsuit that you filed against them. If it's some, I don't know, smaller company, they may not have the resources to be in a lawsuit with you. So if you do file a lawsuit against them, they've got to go out and hire an attorney. They're going to ask their attorney for a budget. That attorney's, is probably going to give them a number that would shock their system. And they may say, you know what, we picked on the wrong person this time, or we're just going to let this one go. And so you work out a deal or a settlement with them, and you never have to worry about them again. So it really is very fact dependent on who sent you the letter. What site are you scraping? Is this a site you might be able to say, okay, I'm just going to let this one go because I don't want the trouble. It's a business risk. We're just going to let this one go. The project that I'm doing is not important enough, and we're just going to let this one go. So you have to take in consideration a multitude of facts and just do your best. And there is no one right answer. So if it's okay, then moving to to standards, I heard from you, and working in the scraping industry also, I think all of us have the feeling what is the good standard is, I guess it is public data, that the data that we're scraping should be public. Could anyone elaborate more on this? What could be considered public? When do we determine that the data is public or whether it's private? And after this, we can move on to the other standards that should be followed.
I think what Midigas talked about earlier on, his analogy of the shopping mall is absolutely superb, and I think it really speaks to what we're dealing with here. If you go to a website and you imagine yourself entering this shopping mall, and if a shop is open and all of the data is there, and there's no obvious restrictions saying you should not go in here, you should not take this, and if you go to the website, let's say, for example, and it's like a clothes store, right? Well, you know, that's fine. You go into it, or it's an online e-commerce retail store. It's fine. You go in. Let's say it's one of those naughty shops on the corner, right, in a back street, and it's got, like, you know, red windows, right? Well, they're kind of telling you that there's something in there that, you know, is probably a little bit dodgy, and maybe you don't want to be, you know, poking around in it too much. And if you look at some of the case law that went down that you're going to move on to as well in the next stage, I think it's critical to go back constantly to what Sania has said, which is have a checklist. And your checklist is the data open and available? Do you have to actually sign in to get to the data? And if we compare this to Midigas's analogy of the shopping mall, is there a security guy there at the start of the door? And does he say, no, you're not coming in unless you got a passport or you got a membership, right? So, you know, let's take that as an analogy in our heads. And if we don't have to sign in, well, then it's probably open. If we do have to sign in, that means there's a barrier. And in actual fact, this was the thing that Ryanair won out on. They didn't win out on the fact that their data was special, because it's not special. They won out on the fact that somebody went in and signed in, and by the very act of, even automatically as a robot, automatically dynamically signing in, they accepted the terms and conditions, right? Because somebody had to specifically program a robot to check that box. It wasn't like you can say, oh, it just did it automatically, right? It didn't. Someone had to program it. So therefore they accepted the terms and conditions, and that's where they fell down. And I think also, you know, obviously we look with prudence at things like, is this open data? Is it personal data? Is it data that was, despite the fact that it may be open on the web, it could be an S3 bucket that you've happened across. It could have personal information in there. It could have highly sensitive information in there. So just because it's open does not mean that you should touch it, okay? It may be open for a faulty reason, some kind of security breach, okay? I think that finally, the last thing I want to say on this is that while you go in, and you should have absolutely, as Sania has said, because she's an active practitioner in this area, right? While you should actually go in every single time you're approaching a new website and go checklist, checklist, I think one of the key things that a lot of people forget about is the ongoing governance. You can't just go in and do it once. You must come back on a regular basis and say to yourself, has anything changed, right? And you must go and you must say, has the terms and conditions changed? Is there now a user and password to get in, whereas previously the access point that I went in on didn't have user password? I'm still going in via this old API that wasn't there, 6 months ago, but they just forgot to close it down. In actual fact, to get in now as a fresh, compliant user of the website, I do need to sign up. So it's not just a case of going through the checklist when you sign up with or you analyze the website in the first place. It's ensuring that you have governance in place to ensure that you remain compliant, so that you don't get into trouble. And you can't just say, oh, I thought it was okay because it was okay 6 months ago. Well, yes, but so too is the 1874 Personal Information Act, which has been superseded by GDPR. GDP what? So you must keep up to date, not only in your law, but also in your own governance of your own actions. And that's a critical point to put across, I think.
Yeah, I definitely agree with that, Alan. The checklist is not a one-time thing. It's an ongoing, living, breathing document that stays throughout the course of a project. You need to be, that's why we train everybody on it here, because it's not just the sales guys and the solution architects at the beginning. It's the project managers. It's the delivery engine. It's the people who design our products. It's at every stage that checklist needs to be looked at on an ongoing basis. So I 100% agree. And then to the point of public data, I think like the very simple terminology we use here is, if you have to explicitly consent to the terms and conditions in any way, you need to be reading those. So it could be that that's behind a login, and that is 99% of the time when you are explicitly agreeing to terms and conditions. But it could also be a pop-up on the website that just pops up and says, you agree to our terms and conditions, and then you are clicking OK, or your automated spider is clicking OK. That affirmative consent is really, really important. And when you're explicitly consenting like that, that's where you need to be really mindful of those terms and conditions and what they say. Again, to Alan's point, like the Ryanair case, it wasn't about copyright. The court said, flight data, that's not unique enough. That's not copyrightable. But you can have something in your terms and conditions, even if it's not copyrightable, that says, don't scrape my data. So that's where you need to be really cautious. It's that explicit consent is where you need to be really careful, I think.
Thank you. You touched really interesting points and both really solid advices from Sene and Alan. But talking, and I love the security guard example. But so far we have talked that the security guard is the password wall, the login wall, as we say it. But can security guard be understood as something else? Like, can security guard be understood as when a company blocks certain IP addresses or when it shows CAPTCHA? Does it make the data public? I'm really interested in discussion here.
Well, from my perspective, again, it's a good question, right? Have they created a de facto click-through agreement by adjusting IP addresses such that it becomes more difficult, or you have to then take additional affirmative steps to circumvent their restriction? My view, and looking at how the case law is playing out, and by case law I mean the past 5 or 6 years, not the past 20 years, because way back when I don't think courts really understood the technology and how it was going to pan out. So whenever I'm asked about an opinion in this area, I generally look to the past 5 or 6 years, not, well, back in 2004, this was, in 2004, it was an entirely different paradigm. I don't personally think that the case law would support a de facto click-through agreement just because they have made it more difficult to get into the website. Again, there is nothing that one has to, there are no terms that one has to agree to. There are no conditions. There's no credentialized gateway. All they've simply said now is where you normally used to take a right turn, now you can't make a right turn. All right, well, I'm gonna make a left and a left and a left and a left. Eventually I'll just make a U-turn. I could still get there. It's not like you've imposed additional restrictions on me, especially contractual restrictions. So in my opinion, changing the IP address does not create a de facto click-through agreement.
Great explanation. Thank you, Brad. And I think that scraping community couldn't think otherwise, because like at some point, the companies that have public data and that they try to defend that public data could be, I could say they could act unreasonably if they would say that their agreement is valid just because they try to IP block you or just because they put CAPTCHA there. So real thanks for this explanation. Then moving on, I think what we also established that it's better, not necessarily it's white or black, but it's better if the data is not unique, it's not copyrightable. I think we have also established that as a standard, that it's safer to scrape data that is not copyrightable. And here I remember one interesting case where I think it was in Florida actually, where I think it was CompuLife Insurance one insurance provider was scraped by another insurance provider, and that insurance provider scraped public data, but it scraped all of it, like the whole database of public data that shouldn't be like actually copyrightable because it's just facts and numbers. But the court made an interesting decision here. Maybe someone has heard this case and could elaborate here.
I don't know this specific case, but I do know that general concept. It was discussed as a general concept when I studied in the Law Society in Dublin. And what they said was that, and maybe it was based on this particular case, but in this particular set of circumstances, they said that the court said that it is reasonable to expect when you put up a website that an individual will go in and will take value from a reasonable amount of individual data points, as they call them, that they could take down or view at a reasonable scope. However, using an automated means to go in and scrape the entire thing was not reasonable. And this is what they said, because these people had put some effort into creating this particular database. Therefore, it had an inherent value above simply a listing of facts. And therefore, it held some copyright value. And it was the expectation of the company that when they put their system on the web, it was for individuals to have individual value gain and benefit, and it wasn't for a competing company to come in and take their entire system as one lump. And I believe, and again, I'm not sure it was that one, but the one that the lecturer was talking about said that it was actually settled out of court, then it didn't proceed. So whether or not it's the same one, I'm not sure. But the interesting point that came up was that in this case, it wasn't simply a list of facts. There was some added value. Therefore, database copyright came into play. And in addition, the court certainly held the opinion that putting something online for the benefit of the individual person does not necessarily mean that it should be accessed as a whole by somebody else for competitive benefit.
I think this is basically the point I always wanted to raise. Alan actually has touched basically the heart and the nerve of what we call the intellectual property right defense, and we have several cases here in Lithuania where I am involved as a plaintiff, and what we are defending a look and feel of the shop. Right, and we exactly are. I mean, of course, this is the offline paradigm, but it's very important to understand where we are heading. And exactly, we are using very same line of argumentation, saying that, look, I mean, the shop is the grocery, retail, and so on is in a way some kind of public place, and of course, it's private place, but it's meant for public use, and basically, it's meant for the consumer's use, and it's meant for the user's use, right? And it's totally different thing when a competitor or not competitor, it's different thing starts to copy, starts to make photos and to fix a lot of different touch points. Let's say it's not only navigating the shop as every user, right, is doing on a daily basis, but making photos, making graphs, making charts and drawings, and start to copy the whole essence, right, of what the shop consists of. And what we're trying to say is that, look, this is basically protected. I mean, it's not protected from users as such, but it's protected from basically scraping the idea and scraping the concept and scraping the elements and fragments of the concept which makes up the store. And the store exactly consists of everything which is publicly available. I mean, you can really touch everything as a user, but what is being protected is the design as such and look and feel. I mean, putting that paradigm on the online world it's basically the same thing which should be applied to the investments made, the substance and the value in the assets created. And if the data scraper tries basically to free ride on that value, free ride on these investments, and not just because it's written in the terms and conditions, because as I've said, I mean, you can write anything you want in the terms and conditions. Basically, we had anecdotal cases where on the 1st of April, basically 4 million people have agreed to writing the souls to the devil just because they have clicked, I agree. I mean, you can write ridiculous things in the terms and conditions. Right, but what you can, I mean, wriggle on off is basically the very idea, the common sense idea, what is being protected and what the owner, the business owner, wants to protect. And so basically, if you just if you scrape the whole database, which was, I mean, invested and which costs like several millions to maintain every year, yeah, it's already the issue, which is not just the terms and conditions thing, but yeah. Public data, by the way, is the concept which is very well known in European law, and it's related to the open data. And the public data is not just the data which is publicly available. Public data is the open data, and we have specific regulation, which is 2019 regulation on what is meant to be public data. Of course, public data is not only the data which falls outside the GDPR or personal data perspective. Public data is the data which has specific value for the society, which is geospatial data, mobility data, company ownership data, and it's specifically regulated, right? So this is also.
If I can jump in there, I think that there's a parallel.
Subject to specific regulation, but private data may also be public data if it was publicized. So it's then not public open; it's public private data.
Yeah.
If there's a quick thing to point out, and I think it kind of wraps this up nicely, actually, Dennis. You know, what Sania amplified there was the importance of going back and having this as part of your governance, is revisiting those sites, revisiting the reasons that you scrape, and revisiting your validity and your compliance with those sites. And I think if we overlay that on what Mindaugas has just said, what he's actually saying is that, and I think also what Brad and Stephen are saying, is that it is also as critical from a legal perspective to ensure, especially as Brad said, we don't live in 2006 anymore, Toto. This is no longer Canvas. It's now, 10 years has moved on, and what happened then is completely out of date. So not only do we have to go and revisit these sites as part of our governance, we also need to keep on top of the current, not only the current legislation, but also the current developments in the courts across the complete gamut of jurisdictions that we have, not only that we deal in directly, but that have an impact on our areas that we deal in as well, because we know that the impact of what someone says in a federal court in Louisiana may well have an impact on a judge who makes a decision in The Hague.
Definitely. And thank you for that. And just also for the wrap up, I think our speakers and listeners are always interested, and customers are always interested exactly into the case law. And I agree that there's the whole world of case law that everyone should follow, but there are probably these like fundamental and groundbreaking ones that could impact scraping in one way or another. So for the wrap up, it would be great if you could share your thoughts on those cases, maybe specifically on Van Buren case and how likely it is to go one way or another, and on Oxylabs and LinkedIn case, how likely it is to be even taken even heard by the Supreme Court.
Maybe Stephen and Brad would be good for that, since you were actually litigating and you're up there in front of the man with the curly wig.
Exactly. Thank you.
I'll throw my hat in the ring as a former U.S. litigator as well there.
Thank you.
Sure. So I can just address Van Buren very quickly. For those who don't know, this is a case currently pending at the United States Supreme Court. It involved a police officer, a corrupt police officer, who essentially, in exchange for monetary value or doing somebody a favor, who he was this suspect fellow he was doing business with, agreed to use his access to a license plate data to improperly run a search and tell the other guy, the no good guy, as to whether a particular person was or was not an undercover informant. And so we're dealing with the situation where the police officer, who has now been charged for a violation of the Computer Fraud and Abuse Act, had access to the license plate database. However, the access was limited solely for doing his job as a police officer and not running searches to help out common criminals on the street. And so the question is, did he exceed his authorized access when he went into the database and pulled the plates and then advised the criminal whether somebody was or was not an undercover police officer? And in the US, our circuit courts, which are essentially the courts that decide cases in the various parts of the United States, are split on this question. The 11th Circuit, where this case arose, came out and said that, yes, if you have access to a computer and your access is for one purpose and you use it for a impermissible purpose, that is a violation of the Computer Fraud and Abuse Act. And the 11th Circuit upheld his conviction. That is in contrast with, I believe, at least the Ninth Circuit, who essentially says that, if you have access, what you do in your mind or why you're doing it, et cetera, does not exceed the authorized access. And this question, the circuit split, is now before the United States Supreme Court. It was recently argued on appeal. The transcript is available. I read the transcript. And what is really motivating the justices, not so much for this, nobody really cares about this corrupt police officer, right? And so he presents a set of facts where you might just say, look, what he was doing is wrong, and let's uphold his conviction. But what's really motivating people and what's really motivating the justices, not so much this corrupt police officer, it's us, every one of us here. We work for companies, and our companies have a policy. You cannot use your company emails for personal use. And when you send that email to your significant other or spouse about picking up the kids, have you just potentially subjected yourself to a felony under the Computer Fraud and Abuse Act? And I think everybody would say, no, that is absolutely silly. Okay, well, maybe. But how do you distinguish it from this gentleman? There was a policy and he violated the policy. Your work allows you access to the computer with a policy. You violated the policy. Or what about a Netflix? You have a Netflix account. You're not supposed to share it. You share it with your brother and he watches some Netflix. Have you just made yourself a felon? And so that is what is sort of driving the hard questions that the US Supreme Court is being asked to address. With everybody sort of realizing that the statute originally was a computer hacking statute. And this guy didn't hack the database, right? He had authorized access. He just used it for an improper purpose. And so that will be interesting to see. I am hopeful that that this guy, not hopeful for him because what he did was bad, obviously, but brings us to a separate question. Are there other laws that could apply and criminalize what he did? Nearly certain. That he, committed wire fraud or, some other crime. Police officers say, hey, how about you make a law saying if you have access to the database, you don't use it to run improper searches and rat out informants. So there could be other ways to deal with this, but it's going to be a big decision because what they're going to say is to the scraping world, I think, is if it comes out unfavorably for scrapers if it says, yeah, if you're given access to a database and somewhere along the lines you're told you can only use it for X, Y, and Z purposes, and you're using it to scrape, they're going to say you violated the CFAA. So it's a big decision. It's a big decision, and we expect a decision by June. And I've learned that predictions hardly ever work out. So I'm hopeful, but we'll see.
I'm hopeful as well. I read the oral argument too, and it did seem like the court understood that potentially the implications of saying that if you have access to a computer system but use it for an improper purpose, that could reach to all of us, like you said, and it is a bit of a ridiculous result for this very old kind of antiquated anti-hacking law that was not very well drafted, and everybody kind of understands that it was not well drafted. And so I am hopeful that the Supreme Court is actually going to go the way we want them to go on this, and that they will say that if you have access to a computer system and you use it for what might be considered an improper purpose or something like that, it's not a violation of CFAA. That doesn't mean there's other causes of action that could not apply, but you're not criminally liable under this law. So I think I do think it'll go the right way, or at least I'm hopeful.
Thank you.
I agree. I'll tell you the CFAA briefly. The CFAA was created in the 80s. It was amended once in the 90s. Okay, so the last time that the Congress even looked at this was about, give or take, if my math is correct, about 25 years ago.
Back when you were doing your hacking, Brad?
Yeah, well, I wish I was that young that if you subtract 25, I'd be 13. But anyway, thank you for that. I'll tell you that the world was a very different place 25 years ago. And what I guess for people who are listening to this and don't quite understand the whole legality of it and how things work, I could break it down just this way. What courts will often say, especially the Supreme Court, they'll say, look, if a statute was intended to cover something, if Congress wanted a law to cover something, then they would have said that, right? They would, if Congress passes a law saying you cannot do A, B, and C, then you can't do A, B, and C. Now, somebody to come in and say, well, how about QRS, right? It's similar. What courts will very often say is, if Congress wanted to regulate QRS, then they would have said you can't do A, B, C, and QRS. But they didn't say that. So if Congress wants that, let them pass a different law. Well, I guess my position is the same as what you've heard just now. Congress passed a law in the 80s and 90s, back when people were using BBSs and 1200, 2400 baud modems. And it was really intended to prevent hacking, access to a government computer, later amended to include private computers attached to the internet. That's it. It's a hard stop right there. They did not, as Steve correctly pointed out, they did not contemplate, and if you read the legislative history, they did not contemplate what was in the mind of the actor when he or she did that. What was I going to do with the information? What were we gonna sell it? Were we going to just look at it and frame it? It didn't matter because the focus was on access. Okay, so now what these new cases, I believe, are trying to say is, well, we're going to extend the scope of just access. Now we're going to extend it to what you're doing with that information, or what your purpose is after you're already in. And to me, the only reason why courts have even allowed that to happen is because some lawyers somewhere send cease and desist letters, right, saying you can't use the information that you've seen, and if you do, it violates CFAA. And so lawyers have extended the scope of CFAA, and somehow, some way, I think, before courts really understood what was going on, they sort of looked and said, yeah, sounds about right. But if you really take a step back, it's lawyers and cease and desist letters that have extended the scope of this statute. The statute is an anti-hacking statute. It is an anti-access statute, and that's it. And I believe that in the current status of our Supreme Court, where you have the majority as conservative, strict constructionalists, if you will, whether you agree or like that or not, that's what it is. I think at least 5 of them are going to take that view. My prediction that they're going to say, this was an anti-hacking statute. If the legislature wanted to then go into, like what Steve said, let's talk about what you're thinking about doing with that information, then they have to pass another law that says that. And like Sanaya just said, there might be other laws that they could use, but it ain't the CFAA. Okay, it's not that. So I think that that's the way it's going to go, but we'll see.
Yeah, I think it's a great finish for our webinar, and I definitely know that all of us in the scraping community have something to wait for now, and hopefully justices will be as reasonable as you all are. And I really want to thank all of you for your time, your input. I know that our listeners definitely learned something new today, and I know that we have talked about legal things, but we also have touched practical aspects of scraping. So again, I really appreciate your time, and thank you for that.